the Supreme Court docket just became our most critical battlefield. After decades of insidious erosion of our Second Amendment rights, the United States Supreme Court is finally intervening. This term, the court has quietly accepted monumental cases that will redefine gun ownership laws nationwide. Among the urgent challenges are California's magazine capacity ban, Washington's detachable magazine prohibition, Cook County's aggressive assault weapon ban, widely considered one of the most restrictive in the nation, and the federal mandate disarming non-violent felons. Other cases challenge carrying restrictions in Hawaii and the federal prohibition against firearms for unlawful drug users. If the court applies the ironclad Bruen framework, we are on the precipice of a historic affirmation of our right to bear arms, a judicial thunderclap that could obliterate decades of unconstitutional restrictions. Join me now as we dissect these crucial cases and expose why our vigilance in this fight is a crisis of liberty. The United States Supreme Court is poised to confront a terrifying avalanche of Second Amendment disputes, a confrontation that will irrevocably reshape the legal matrix of gun regulation across this country. Over the last decade, the court's judicial philosophy has shifted with seismic force, abandoning the flimsy, interest-balancing approaches lower courts use to justify restrictions for the stringent history and tradition framework established by New York State Rifle and Pistol Association versus Bruen in 2022. This doctrinal pivot has triggered a relentless wave of challenges against state and federal statutes that regulate firearms, their accessories, and the rights of specific citizen categories to possess weapons. A dangerous cluster of high-stakes cases now demands the court's attention, encompassing detachable magazines, blanket bans on semi-automatic rifles, the so-called assault weapons, the lifetime disarmament of citizens with non-violent felony convictions, crippling restrictions on carrying firearms on private property open to the public, and federal prohibitions based on unlawful drug use. The outcomes of these cases will either firmly entrench Bruen's historical test as the dominant, inescapable standard for evaluating modern gun control schemes, or, catastrophically, carve out treacherous exceptions that grant legislatures broad, unchecked regulatory authority. At the immediate, high-stakes epicenter of this controversy are state laws that impose draconian bans on detachable magazines capable of holding more than 10 rounds. California's Penal Code 32310, enacted in 2016, strictly prohibits the possession of such magazines, a prohibition that has generated years of protracted, costly litigation. Following the law's passage, a brief, chaotic enforcement pause, infamously dubbed Freedom Week, allowed tens of thousands of residents to acquire standard capacity magazines before the ban fully took effect. Federal. District Judge Roger Benitez twice declared the California ban unconstitutional, concluding with judicial certainty that magazines constitute arms in common use, and that the prohibition could not withstand constitutional scrutiny. Those crucial rulings were reversed on March 20, 2025, when the Ninth Circuit, sitting en banc, handed down a devastating decision. Magazines are accessories, not arms. The state's ban aligns with a dubious long tradition of regulating particularly dangerous weapons. And the restriction, they claimed, does not meaningfully burden the core right of self-defense. If the Supreme Court refuses to grant review of the Ninth Circuit's egregious decision, the ruling stands, and Californians who currently possess standard magazines face the imminent, terrifying prospect of surrendering or permanently disabling property that is absolutely vital to the functional capacity of their firearms. A parallel, legally devastating development in Washington state has dangerously amplified this legal uncertainty. On May 8, 2025, the Washington Supreme Court, in State v. Gators Custom Guns, concluded that magazines are definitively not arms protected under the Second Amendment and therefore fall completely outside its constitutional shield. The court relied heavily on dubious legislative findings that high-capacity magazines increase casualties in mass shootings, and that restricting them reduces gun deaths. Retailers and industry groups argued vehemently that the law criminalizes standard essential equipment for semi-automatic rifles and handguns, but the court brazenly framed the restriction as a reasonable safety measure. Petitioners seeking review in the U.S. Supreme Court received a distribution of their petition for the court's December 5th conference, a clear signal, and the case has already attracted a deluge of amicus briefs from both sides of this foundational debate. The core, existential legal question presented by the petitions stemming from California and Washington is deceptively simple in form, but utterly catastrophic in consequence. Are detachable magazines arms protected by the Second Amendment, or are they mere accessories that states can regulate or ban based on a claimed, often invented, historical tradition? Those who aggressively challenge these magazine bans emphasize that detachable magazines are utterly integral to the operation of all modern semi-automatic firearms, and that they have been in widespread common use since the late 19th century, a historical reality that proponents argue places them squarely within the category of arms in common use for lawful purposes. Critics of the Ninth Circuit's shocking en banc decision contend that treating magazines as accessories directly conflicts with the foundational District of Columbia versus Heller decision, where the court recognized that the government's absolute inability to ban the quintessential self-defense weapon was decisive. The Washington ruling further poisons the well by grouping magazines with other firearm attachments that the court deemed outside the amendment's protection. A Supreme Court grant of review could finally resolve a dangerous split among state and federal courts and definitively determine whether magazine bans are permissible under the Bruen framework. A denial, however, would leave the conflicting, hostile rulings in place and inevitably encourage other states to adopt or drastically tighten similar unconstitutional restrictions. Another critical high-volume front involves the sweeping bans on semi-automatic rifles. Firearms often maliciously mislabeled as assault weapons, including the ubiquitous AR-15 style platforms. Since 1993, the most populous county in Illinois has maintained a flat prohibition on the possession of certain semi-automatic rifles, and in August 2025, the Seventh Circuit shockingly reaffirmed the constitutionality of that county's oppressive ordinance. The Seventh Circuit, relying on a deeply flawed legal rationale, claimed that semi-automatic rifles are essentially the same as military-style firearms, and therefore fall outside the core protection of the Second Amendment. The court summarily dismissed conclusive evidence that millions of AR-15s are lawfully owned for crucial self-defense and sport purposes, concluding instead that the weapon's alleged design for combat somehow justifies this fundamental restriction. Challengers, including the powerhouse Second Amendment Foundation and the Firearms Policy Coalition, filed a certiorari petition, arguing with urgency that AR-15 platform rifles are the most popular rifles in the entire country, and that blanket bans on them violate both the Second and the 14th Amendments. They are urgently imploring the Supreme Court to settle the assault weapon ban issue once and for all, flatly contending that multiple federal circuits have dangerously misapplied Bruen. Respondents counter that the ordinance is narrowly tailored to reduce gun violence. The petition was distributed for the court's December 5th conference. A grant could result in a landmark ruling that either invalidates assault weapon bans nationwide or, ominously, upholds them under a flawed historical tradition analysis, while a denial would leave conflicting appellate rulings intact and invite continued expensive litigation. The constitutionality of the lifetime disarmament of citizens with felony convictions is yet another crisis generating destructive circuit splits and urgent petitions for Supreme Court review. Federal law, specifically codified in the Oppressive Gun Control Act of 1968, makes it strictly illegal for anyone convicted of a felony punishable by more than 1 year in prison to possess a firearm, regardless of whether the underlying offense was violent or decades old. Historically, courts have generally deferred to and upheld this broad prohibition. But the Bruen history and tradition test has compelled a renewed, vigorous round of challenges, particularly when applied to nonviolent felons whose convictions may be decades old. In 2023, the Third Circuit held a crucial line, ruling that Brian Range, convicted of a nonviolent welfare fraud offense, retained his Second Amendment protections because the government could not demonstrate a historical tradition of permanently disarming nonviolent felons. That crucial decision immediately created a conflict with other circuits. In 2025, the 10th Circuit in Vincent v. Bondi upheld the law, finding that disarming felons has a long pedigree and that precedent such as Rahimi did not displace that tradition. The 9th Circuit in United States v. Duarte also upheld the law on May 9, 2025, agreeing that bans on gun ownership for felons align with Bruen and Rahimi. Petitioners seeking Supreme Court review argue that Bruen fundamentally requires the government to show clear historical analogies for disarming nonviolent individuals, and that many people with old, nonviolent convictions should not be permanently stripped of their core, inalienable right to self-defense. A favorable ruling for petitioners could justly restore firearm rights to hundreds of thousands of Americans. A denial would leave the circuit split unresolved and force the issue onto Congress or into future costly litigation. The court is also scheduled to address state laws that brutally flip the default rule for carrying firearms on private property open to the public. In direct response to the Bruen decision, states such as New York, New Jersey, California, and Hawaii rushed to enact sweeping statutes that now require property owners to affirmatively post signs permitting concealed carry on their premises, effectively banning permit holders from carrying on most private property open to the public unless explicit permission is posted. Hawaii's law, for example, designates a paralyzing number of sensitive places where firearms are forbidden and brazenly bars permit holders from carrying on private property open to the public unless the owner posts a sign allowing it. The Ninth Circuit upheld such a law and rejected an en banc rehearing, compelling 3 Maui residents and the Hawaii Firearms Coalition to petition the Supreme Court. The U.S. Solicitor General filed a rare and significant amicus brief, urgently pleading with the court to hear the case, noting that similar restrictions now apply in states encompassing more than 1/5 of the U.S. population. The court granted review in Wolford v. Lopez in October 2025, setting the stage for arguments in early 2026. The case will be the ultimate acid test of whether states can effectively render public carry illusory by aggressively shifting the burden onto property owners to permit firearms, and whether the flimsy post-Reconstruction regulations relied upon by lower courts are adequate historical analogies under Bruen. Finally, the court has agreed to hear a pivotal case that dramatically probes whether habitual users of illegal drugs may be permanently disarmed under federal law. The Gun Control Act, in yet another overreach, prohibits anyone who is an unlawful user of or addicted to any controlled substance from possessing a firearm. In January 2025, the Fifth Circuit courageously struck down the statute as applied to a marijuana user, reasoning that there is no historical justification for permanently disarming a sober citizen not presently under an impairing influence. The Justice Department, in a transparent move to maintain federal control, appealed, and the Supreme Court agreed to hear United States v. Himani, likely referring to a generic future case or mistranscription of Daniels. A high-profile case involving allegations that a defendant was a regular marijuana user whose pistol was discovered during an FBI raid. Petitioners argue that Bruen stringently requires the government to demonstrate clear historical precedent for disarming nonviolent, sober individuals based solely on past drug use. A ruling in favor of petitioners could have colossal, far-reaching consequences in states that have legalized marijuana, but remain subjected to federal prohibitions. Taken collectively, these cases present the Supreme Court with a catastrophic menu of consequential choices about how to apply the Second Amendment in the modern era. If the justices insist on rigorous, undeniable historical analogies for every modern regulation, many contemporary draconian gun laws could be rendered immediately vulnerable to litigation and nullification. If, however, they begin to carve out ambiguous exceptions or allow more deference to legislative judgments about public safety, states will feel aggressively emboldened to maintain or dangerously expand restrictions. Either path will have profound, destabilizing implications for public safety policy, criminal justice, and the fundamental rights of millions of Americans. The coming months and years will determine whether the court reaffirms a robust, historically grounded protection of the right to keep and bear arms, or permits a broader, more dangerous scope of regulation in the name of contemporary public safety concerns. Observers on all sides of the debate are watching with bated breath, acutely aware that the court's decisions will not only resolve the immediate disputes, but will also set treacherous precedents that will guide lower courts and legislatures for generations. We stand at a constitutional crossroads, a point of no return. Either the court will honor the Constitution and our history, or it will allow infringements to proliferate into a permanent crisis. Stay informed, relentlessly share this urgent message and support those fighting for our rights. Stay ready, stay armed, and stay.